So, good morning, everyone. Good morning, everyone, if you're on the West Coast. Good afternoon if you're on the East Coast, and good evening if you're in Europe or Asia. Welcome to the first TSCA 3030 of 2021. So what are we going to talk about today? Well, we're actually going to talk about a recent court case involving asbestos and the CDR reporting rule and its implications for future risk evaluations. Next slide, please. I'm Herbert Stryker. I give a lot of these. You may note that I've not recently given a TSCA 3030. I do the REACH 3030s, but I'm back. Next slide. I'm joined by my partner today, Greg Clark, who's given a number of these as well. Next slide. So what's the context? Well, you know, if you've been following EPA's efforts with respect to risk evaluations, particularly the first 10 chemicals, you will note that they've been heavily criticized by all quarters, NGOs, the peer review panels, the SAC, and others, for not having a great deal of information to support the risk evaluations. And NGOs have urged EPA to use their rulemaking authority, particularly TSCA Section 4 and 8, to mandate testing and require reporting in order to fill data gaps for the substances that are undergoing substance evaluation. EPA under the Trump administration has relied primarily on voluntary submissions by industry. The environmental groups have argued that voluntary submissions has proven wholly insufficient. And to sort of try to prompt this, there was a series of cases brought by NGOs and state attorney generals to require EPA to amend the CDR reporting rule to require more information on asbestos. That petition was denied, and then there have been a series of court challenges, and we're here to report on the outcome of these court challenges. Next slide, please. So there were two cases. I give you the references here. They were both brought in the Northern District of California, federal court, and both before Judge Edward Chen. And if you've been paying attention to some of our earlier TSCA 3030s, Judge Chen is the same judge that's been presiding over the fluorinated water TSCA cases. Next slide, please. So what's the background? Well, as you know, asbestos is one of the chemicals identified by EPA as one of the top 10 to be evaluated under the Lautenberg amendments to TSCA. ADO, which is environmental group, notified EPA under TSCA Section 20 that a chemical company, had not reported asbestos imports for 2016 CDR. EPA wrote a letter to Occidental telling that was not a problem because their particular asbestos imports were exempt under the naturally occurring chemical substances exemption. This led the environmental group ADAO to petition under Section 21 of TSCA to file a petition. Next slide, please. So what did the plaintiffs ask in the petition? They asked that EPA initiate rulemaking to expand the chemical data reporting rule as follows. Eliminate the, quote, asbestos exemption, this is a naturally occurring substance exemption, lower the reporting threshold, eliminate exemptions for impurities in articles, importantly, require reporting by processors, require immediate submission of reports on asbestos for a 2016 reporting cycle. Basically, the environmental groups have brought petitions under Section 21 to try to force EPA to initiate rulemaking to expand chemical data reporting requirements, to eliminate the asbestos exemption, lower the reporting threshold, eliminate exemptions for impurities in articles, require reporting by processors, require immediate submission of reports on asbestos for the 2020 reporting cycle, and not allow any CBI claims in connection with these CDR reports. Next slide, please. So what was EPA's response? EPA denied the petition, and they argued the following 5 items. They said that the asbestos exemption, which was an exemption that EPA asserted qualified, that asbestos qualified for on a naturally occurring chemical provision under the CDR, that the asbestos exemption only applied under specific circumstances that were described in the letter to the chemical company that had not reported asbestos for the 2016 CDR. And as you may recall, and hopefully we had some, I was not on mute when we said this, that EPA had advised Occidental that they did not have to report asbestos for the CDR because they were exempt on the naturally occurring substance exemption. They said that exemption only applied to specific circumstances that were at issue with respect to the Occidental Chemical Company imports. The second basis for denying the petition is that they said that amending the CDR to require requested information on asbestos would not result in a reporting of any information that is not already known to EPA. They also said that there was no time to collect additional information before the asbestos risk evaluation was finalized. They said there was no evidence that asbestos impurities are the result of the manufacture of asbestos. And they also said that disclosing CBI would have no practical relevance to the risk evaluation or risk determination because CBI claims are limited under CDR and that EPA can in any event evaluate the information without revealing the actual CBI data. Next slide, please. So what is the procedural posture of the cases? As I mentioned, there are two cases that were brought, one by environmental group, ADAO, and another by 10 states attorney generals plus the District of Columbia. Now, these petitions actually asked for an amendment of the existing CDR rule rather than the new rulemaking. And so therefore, that type of lawsuit is decided under the Administrative Procedure Act, the APA. And because it's under the APA, the normal de novo review that one would obtain under a TSCA 21 petition by the court did not apply. So the environmental groups in the states moved for summary judgment. They argue that the EPA denial of their rulemaking petitions was arbitrary and capricious as a matter of law. EPA filed cross motions for summary judgment in both cases, basically alleging that they had the information, sufficient information to make do a risk evaluation of asbestos, and that the information requested in the TSCA 21 petitions would be duplicative and unnecessary. Next slide, please. I'm going to turn this over now to my partner, Greg Clark. Greg?
Thank you, Herb. So let's talk a bit about some of these data gaps, and this would be the rationale for requiring EPA to amend the CDR with respect to asbestos. So ADAO, in its petition and in its brief, alleged that there were key data gaps that related to what would have been reported under the CDR were it not for these various exemptions. And we're not going to go through each of these, but keep in mind, these do seem, I think as we go through, they do seem as the type of information that would be relevant to EPA's risk evaluation of a substance. We're talking about manufacturing sites, import sites, volumes of imports, how much of that is used on a particular site versus distributed off-site, the physical form, maximum concentration, and probably most predominantly important, a number of exposed workers. Next slide, please. You'd also, under CDR, you report the types of downstream processing or use, information on the nature of the use, as well as the sector of the economy that falls into, and then a percentage of that, percentage of the overall volume that's dedicated to each use or expected for each use. The number of sites, again, that goes to exposure, a number of workers, whether products are intended for use by children, and then maximum concentration of the chemical and the products. So you see that there's overlap here with what would be relevant to EPA's risk evaluation, but the question is more so whether this data is actually available for the gaps that are alleged by ADAO. Next slide, please. So the SAC report, SAC reviews each of EPA's draft risk evaluations. And although this was released in August of 2020, the court took judicial notice of this, even though it's not part of the record before EPA at the time that they acted on the petition. There are, though, a number of recommendations and comments that the SAC made that are relevant to the question of whether there are data gaps that EPA should have acted to fill. In particular, the SAC recommended that EPA use its statutory authority under TSCA to request additional data on occupational exposures. Also recommended that EPA confirm and incorporate the latest information from the U.S. Geological Survey on manufactured products that are imported into the U.S. and actively collect data on imported products that are suspected of containing asbestos instead of relying exclusively on voluntary reporting. Next slide, please. In addition, the SAC recommended that EPA require reporting of numbers of potentially exposed workers from industrial facilities that process asbestos, provide information that identifies the data gaps within the risk evaluation so that that's more specified. This was not a recommendation, but the SAC did note that the USGS data on imports, there were certain HTS codes, and those are the classifications of imports for purposes of tariffs, but there are certain HTS codes that corresponded to imports of asbestos that were not addressed within the draft risk evaluation specifically. And they recommended that EPA address that. And then finally here, I would note that the last bullet, defining a minimal data or information needed to produce a reliable and confident estimate of risk. I think it's worth noting that the SAC put this to EPA's discretion and determination and expertise to determine what the minimal data was, but requested that EPA do so that it is clear what sorts of information EPA needs to be able to perform its risk evaluation function. Next slide, please. Indeed, in EPA's problem formulation and draft risk evaluation for asbestos, they did identify or note that there were certain data gaps on the conditions of use that they were looking into, that they were evaluating. For example, for brake blocks that are used in oil field equipment, EPA stated that it was unclear how widespread the continued use of asbestos was in this use. For other products, that it was unclear what the quantities were that were being imported into the United States. For sheet gaskets, which were one of the two conditions of use that involved processing of asbestos according to EPA. EPA indicated they were not certain if there were other industries that were using sheet gaskets that contained asbestos. And then in general, EPA noted that the import volume of products containing asbestos is not known. Next slide, please. But I think it's important to note that while EPA acknowledged that there were certain limits to the information that they had for the conditions of use and the products that they were evaluating, that many asbestos-containing products are currently prohibited, were prohibited either at the time that EPA acted on the petition or are now subsequently prohibited. The corrosion-proof fittings case left in place EPA's ban on certain discontinued asbestos products. And then in 2019, EPA promulgated a SNR, which in effect prohibited, for all intents and purposes, a number of additional uses that had been discontinued between the corrosion-proof fittings case and 2019. So in effect, many asbestos-containing products were no longer permitted. And so that it helps explain why it was not necessary in EPA's view to gather broad-ranging information on asbestos-containing products. Next slide, please. And I'll turn this back over to Herb to discuss the court's decision.
Yeah, hi, Greg. Thank you very much. So I think that the rulemaking record, established that there were data gaps, and in the face of those data gaps, EPA just decided to proceed anyway with its risk evaluation. And so what the court found is they found that EPA, in its scoping documents and the draft risk evaluation, missed numerous products that were identified in the USGS Minerals Yearbook that contained asbestos. And I'm not going to read all these products to you, but you can see, at least in accordance to the USGS, there are a substantial number of products that, at least in 2015, contained asbestos. The court then concluded that these findings indicate that EPA is not accounting for certain asbestos-containing articles that are imported in the U.S. and for which the quantity of how much asbestos in those articles is imported is unknown. Next slide, please. The court said that EPA has not attempted to quantify the volume of asbestos-containing articles imported in the U.S. The court further found that EPA does not know what information regarding asbestos impurities is reasonably ascertainable, and it cannot obtain this information unless it requires companies to report that information under the CDR. Now, EPA had argued in response to its denial of the Section 21 petitions that its modeling, it was using models, and that was able to use these models to fill data gaps. The court found that EPA's models are not accurate because EPA does not have the sufficient information to input into the models. Next slide, please. So what did the court decide? Well, the court first reviewed EPA's authority under this Section 8A, the CDR provision of TSCA. The court found that TSCA requires EPA to consider reasonably available information when conducting a risk evaluation on conditions of use, and that TSCA defines reasonably available information to mean information EPA possesses or can reasonably generate or obtain and synthesize. Now, the court then compared that standard of reasonably available information to the standard for reporting on the CDR, which also requires companies to report information which is either known or which is reasonably ascertainable. So the court drew the link between what EPA was required, the type of information EPA was required to obtain in connection with risk evaluations, to the type of information that companies were required to report under the CDR. And then the court also found that EPA has significant enforcement power to compel companies to submit information which is known to them or which is reasonably ascertainable under the CDR law. Next slide, please. So, given the statutory authority, given the statutory requirement to base a risk evaluation on reasonably ascertainable information, given the statutory requirement of companies to report reasonably ascertainable information on the CDR, given EPA's powers to force companies to report that information, the court decided that since there were significant gaps in EPA's understanding of asbestos uses and import volumes, as established by the scoping documents, the draft risk assessment, and the SAC review, that EPA had not articulated a satisfactory explanation for not collecting that information on the CDR. The court said, in a very nice sentence, that EPA cannot know what information is reasonably ascertainable and therefore reasonably available to EPA without knowing the full range of potentially available information to be reported. The court considered EPA's excuse that it didn't need this information to do the risk evaluation to be irrational. And remember, under the Administrative Procedure Act, the standard for striking down agency action is that it's arbitrary, capricious, or contrary to law. And so the court concluded that EPA's justification for not requiring the information was not rational, that because that assertion was premised on the idea that EPA knows the full range of reasonably available information in the first place. And since the court concluded that EPA cannot know what it does not know, then arguing that EPA's argument that it already knows everything it needs to know is not a rational argument. Next slide, please. So what did the court decide? Well, respect to reporting by processors. Remember, that was one of the things that the environmental groups asked. They asked that the CDR reporting for asbestos be extended and applied not only to manufacturers and importers, but also applied to processors. So the court concluded that EPA's argument that it already captures sufficient information on the processing of asbestos was not reasonable. The court found that the information that EPA has received on the processing of asbestos comes primarily from importers, that importers are often relatively uninformed about downstream uses, and in many cases are unable to provide detailed information about the use and exposure which occurs with asbestos processing. The court found that EPA's current CDR reporting requirements for processors relying on manufacturers and importers to provide processing information is insufficient. And if you've ever filled out a CDR report, I think you probably recognize that when EPA is asking you for use, processing and use information, it is a real challenge for you to sort of put in meaningful information when you fill out the CDR report. So there's no question, and the court concluded that manufacturers and importers are not the best parties that are suited to provide information on the downstream processing of chemicals. Now, what EPA had relied on in connection with developing its draft risk evaluation was voluntary reporting from companies, and the court felt that voluntary reporting was not sufficient, and that since EPA had the authority to mandate this information from processors, that EPA had not articulated a rational decision as to why it had not done so. Next slide, please. So what did the court order? Well, the court ordered that EPA amend its CDR reporting rule within a, quote, reasonable time, end quotes, and without undue delay, and that the court would retain jurisdiction for the purposes of ensuring compliance. Now, what does this all mean? Well, if you sort of think about it, let's talk about asbestos. Well, as you know, EPA is required under statute to issue a final risk assessment, risk evaluation for asbestos within 3.5 years after the listing of asbestos as one of the first 10. So obviously now the CDR 2020 cycle is due this month. So obviously EPA is not going to be able to amend the CDR rule for the 2020 reporting cycle to do all the things that the environmental groups asked for, which the court concluded that EPA must do. And so let's summarize what those things are. They had to deal with the natural occurring substance exemption. They had to deal with processor reporting. They had to change the reporting threshold to lower it, to capture more reports for asbestos. They had to eliminate the impurity exemption, and they had to eliminate the article exemption. So that's quite a tall order, quite a substantial revamping of the CDR rule, at least for the reporting of asbestos. And given the fact that the 2020 reports are due this month, given the fact that the risk, so obviously EPA is not going to be able to do that. Now, so what can EPA do? Well, it could amend the rule for the next cycle, 2024, but that doesn't make any sense. So my guess is, and particularly the new administration that's coming in on the 20th of January, my guess is that EPA will issue us a PAIR rule specific for asbestos to call in the type of information that the court has ordered EPA to call in. I think that's my sense. Probably what the court's going to do with respect to asbestos. Now, what's going to happen in terms of the risk evaluation for asbestos? Well, there's probably no time to amend the current risk evaluation to include this new information, which I believe EPA is going to mandate. So I suspect they will finalize the risk evaluation for asbestos as it now stands, but they will probably have a supplemental, in my view, risk evaluation to cover the additional uses that are unearthed and uncovered as a result of this additional reporting requirement. But what does this mean in terms, more importantly, I know a lot of companies on the phone that probably don't really care about asbestos, but what does this mean in terms of the broader context of the TSCA risk evaluations on the Lautenberg Act? Well, if you sort of think about it, what does this court decision really stand for proposition? What does it really mean? It means that if there are identifiable information gaps, that EPA has no choice but to use its rulemaking authority to close those gaps. I mean, that's what this court decision means. Now, of course, the EPA could appeal this decision to the Ninth Circuit, but I think Judge Chen's decision is very well reasoned, and so I'm not really entirely sure how an appeal to the Ninth Circuit will fare. And by the way, the environmental groups have been remarkably successful, in my view, in terms of litigating against the Trump EPA in all areas, but including TSCA. And so it's not entirely clear to me that the new administration is going to be interested in engaging in litigation. And they're probably going to do a lot of the things that the environmentalists wanted to do on EPA's own initiative. So the good days are over, quite frankly. So what does this mean? Well, I think, if EPA, when they do a scoping document, feels that there's insufficient information, there'll be data gaps, I really do expect to see from this new administration peer rules. I suspect that the next CDR reporting cycle, 2024, you will see additional requirements for those chemicals that are on EPA's proposed list for risk evaluation. And it may well be all the chemicals that are on the 2014 action plan. I wouldn't be surprised to see that. And I also wouldn't be surprised, at least for those chemicals, to see the obligation for processors to report. So there's going to be a lot of rulemaking around this area by EPA, at least the next administration, in my view. And it's going to be up to industry to decide that whatever EPA plans to do or proposes to do, that it's coherent and that it's practical, and that there's not an overreaction to this case in the district court in California. Okay, next slide, please. So I want to remind you that we're having in 7 minutes our Reach 3030, our January 13th Reach 3030. Our next TSCA 3030 is on February 17th. And as always, the next OSHA 3030 is on January 27th. Next slide, please. So our next TSCA 3030 is on February 17th. And we will be posting, as we always do, the slides and a recording of this presentation. I want to thank you. I'm Herbert Stryker, and we were joined by my partner, Greg Clark. Thank you very much.